The jury is now deliberating in the George Zimmerman murder trial. Let's bring in our legal expert panel. Sunny Hostin, CNN legal analyst. We have Faith Jenkins, a prosecutor, Trent Copeland, a criminal defense attorney, and Richard Gabriel, a jury consultant. Before I get to you guys, I just want to go over who these jurors are. A little different than other juries you may know about. There are only 6 jurors on this panel. There are 5 white women. There is 1 Hispanic or black woman. I misspoke earlier. I said it was 1 Hispanic woman. It is a Hispanic or a black woman. The range in age here is considerable, from 30s to 60s, and most of the women in this jury are married. So Richard Gabriel, jury consultant, first to you. This is a process that could take hours, could take days. What's happening right now in this first half hour?
Well, the first thing that the jurors usually do is sit down and go, who's going to be the foreperson? And usually this can be established even during the trial, because a couple of components happen with 4 people. One is sometimes the most gregarious person becomes the foreperson, sometimes a person in the highest authority position. You have a safety officer, you have a woman also who was the director of a call center who directed 1,200 employees. These are obviously viable candidates for the foreperson. So usually the first thing is who's going to sort of direct this, and then the decision is usually made, okay, how do we go through the evidence? Because there's 2 typical scenarios. One jury is, let's go to the verdict questions and let's vote, or it's, shall we go through the evidence and pore over the evidence? If they go to the vote quickly, then usually you have a quicker verdict. If they spend a lot of time going through the evidence, obviously it can take a lot more time.
Now I want to bring in Trent Copeland. Let me ask you this, because we watched closing arguments today coming from the defense, and then we saw the sort of secondary closing arguments from the prosecution. When you listen to those jury instructions that we heard today, when it comes to second-degree murder and it comes to manslaughter, sort of looking back over this entire case, where do you think, if there is any, the deficit in this case that the prosecution has built that would make it difficult for this jury to find George Zimmerman guilty of either second-degree murder or manslaughter?
You know, look, Brianna, first of all, I think the difficulty in the case began with how the case was filed. First of all, I think this case was filed way overcharged. I think that the case never should have been filed as a second-degree murder case. I think the case probably should have been filed as a manslaughter case if it was filed at all. And so I think right there at the root is where the problem began for the prosecution. So I think, though, under full-order law, what we'll have to assess as this jury goes into that jury room is, when does the case really start? And the case really starts factually when the confrontation starts. And that's where the issues for the prosecution really are the most manifest. What they can't establish is, when did the confrontation start, how did it start, and who started the confrontation. And at that point, really the prosecution's case begins to break down, because we just don't know, we just don't have the answers to it. And so no matter what you think about George Zimmerman, and I've got strong feelings about George Zimmerman and what he did and how he should have behaved that evening, and I think a lot of what he did put all of this in motion, but strictly as a legal matter, the case begins when the confrontation starts. Who started it, who ended the confrontation, and who responded aggressively in that confrontation. And we simply don't have facts to support that. And the prosecution's case really falls, I think, in that area tremendously. And I think that's where this jury is going to hang their hat in probably finding reasonable doubt in this case and not convicting on either charge.
That's right, Trent. Who was the aggressor, and is there reasonable doubt or reasonable certainty, as we heard Judge Nelson explain to the jury there? Right after a break, we're going to be talking about that very powerful rebuttal closing argument that we heard from Deputy Prosecutor John Guy. The jury is deliberating in the George Zimmerman murder trial. We're back now with our legal panel, and we want to discuss what we saw before the judge gave out those jury instructions and the jury went back to begin deciding George Zimmerman's fate. Today we saw closing arguments by the defense, and then we saw a rebuttal closing argument by Deputy Prosecutor John Guy. Very dramatic, I thought, closing argument that he gave. Let's listen to part of it.
This case is not about race. It's about right and wrong. It's that simple. And let me suggest to you how you know that for sure. Ask yourselves, all things being equal, if the roles were reversed and it was 28-year-old George Zimmerman walking home in the rain with a hoodie on to protect himself from the rain, walking through that neighborhood, and a 17-year-old driving around in a car who called the police, who had hate in their heart, hate in their mouth, hate in their actions. And if it was Trayvon Martin who had shot and killed George Zimmerman, what would your verdict be? That's how you know it's not about race.
Imagine, he was saying, if their roles were reversed here. Sunny Hostin, you were in the courtroom during this time. Did you get a sense of how the jury was reacting to what Guy was saying to them?
You know, he had them at hello. He had already established a rapport with them because he gave a very forceful opening statement. His cross-examinations were very colorful. Remember, he was the one that was straddling the mannequin on the floor in front of the jury, with many of the jurors standing up to see him. So he already has this rapport with the jury. And when he got back up, I've got to tell you, a few times they looked at some of the exhibits he was referencing, but every other time their eyes were fixed on him. They did not look away. I hadn't seen that kind of reaction with any of the other attorneys during any of the other statements or arguments. And so I think that they really honed in on what he had to say. It was very, very impressive. And yes, he did argue from an emotional standpoint in some ways, but he also argued the evidence as well. And so I think this jury certainly seemed to connect with him. In particular, we know that there are 5 mothers on this jury out of the 6 women that are on the jury. When he described a child's worst nightmare being followed in the dark, in the rain, by a stranger. I'm a mother of a boy. It resonated with me. I cannot imagine that it didn't resonate with the mothers on the jury.
And so he said that, use your hearts. That's what we didn't hear that coming from the defense when we heard their closing argument. Let me bring in Faith Jenkins. You're a prosecutor. You've served in this capacity. He said there something that struck me, because he said this isn't about race. And yet, to me, that sort of belies that the prosecution is concerned that perhaps it is about race, and that jurors may not necessarily identify with Trayvon Martin, or, as we heard from Bernie De La Rianda, they may not identify with what you could argue is their star witness, Rachel Jeantel. Do you think that's a concern? Is that the right way to read that?
I think they're being very careful here with their phrasing to not make it that issue in front of this jury, and just look at the facts and the evidence and what they've presented and base the case on that. John Guy's presentation, we're taught as prosecutors, in order for a jury to believe in your message, they have to believe in the messenger. And he stood there with such conviction. You could tell he really believed what he was telling these jurors today. And when he talked about that one particular issue, they've used the word profiling a number of times in this trial without using racial profiling, but the words profiling. These jurors know what that means. They know that when they say Zimmerman profiled Trayvon Martin, he didn't profile him because he didn't like the kind of candy he was carrying, but it was because of how he looked and how he was dressed. But at the end, they came back and they told this jury, look at the evidence, look at the facts. Doesn't matter if it was George Zimmerman, if it was Trayvon Martin, right is right, and do the right thing.
Don Lemon, I know you have some thoughts. How effective do you think this closing argument was?
Well, listen, I'm just going to be honest here. If someone who, I haven't watched this from gavel to gavel, as you say, I'm a layperson here, and I'm watching all the legalese and hearing all of you talk about this. To pretend that emotion is not part of a trial or jury is, I think, just completely disingenuous. As someone who has been a juror before, who has served jury duty, and you said decide on certain things, people go into a jury room and they decide based, yes, upon facts, but human beings are not devoid of emotion. And so they also base their decisions on emotion as well. There is a reason that there are 6 women who have children, 6 mothers on this jury. There is a reason that the parents on both sides have testified here about whose voice they're hearing, about what kind of child they have. There is a reason for all of that, and that is emotion is a big part of that reason. And there's a reason that the prosecution at the very end relied upon emotion to give the jury in the end. So to pretend that emotion doesn't play into this, I think, again, is disingenuous. I'm not a legal expert, but I know when those people go into that room, there's going to be emotion in their heart, and they're going to weigh their decision on the facts, of course, but they're also going to weigh their decision on being a human being, and part of that is being emotional.
And the defense certainly knows that in that capacity, they are at a deficit. One of the ways that we saw Mark O'Mara, the lead defense attorney, trying to combat that was by using a block of cement. In his closing argument, he was saying that is a deadly weapon, basically saying that Trayvon Martin had a deadly weapon in addition to George Zimmerman. We'll see how effective our panel thinks that was right after a quick break.
Size Wiki Korea.
코스메 로드.
Be pretty on the Cosme Road. Coming to Korea? Check out Size Wiki Korea.
I have low testosterone. There, I said it. See, I knew testosterone could affect sex drive, but not energy or even my mood. That's when I talked with my doctor. He gave me some blood tests. Showed it was low T. That's it. It was a number.
Today, men with low T have Androgel 1.62% testosterone gel, the #1 prescribed topical testosterone replacement therapy. Increases testosterone when used daily. Women and children should avoid contact with application sites. Discontinue Androgel and call your doctor if you see unexpected signs of early puberty in a child or signs in a woman, which may include changes in body hair or a large increase in acne, possibly due to accidental exposure. Men with breast cancer or who have or might have prostate cancer, and women who are or may become pregnant or breastfeeding should not use Androgel. Serious side effects include worsening of an enlarged prostate, possible increased risk of prostate cancer, lower sperm count, swelling of ankles, feet, or body, enlarged or painful breasts, problems breathing during sleep, and blood clots in the legs. Tell your doctor about your medical conditions and medications, especially insulin, corticosteroids, or medicines to decrease blood clotting. In a clinical study, over 80% of treated men had their T levels restored to normal. Talk to your doctor about all your symptoms. Get the blood tests. Change your number. Turn it up. Androgel 1.62%.
This holiday, experience the time-honored traditions of Europe as you merrily drift among festively decorated towns and Christmas markets all aglow. On board, our warm staterooms and award-winning service and dining await you. So this holiday, spend less time getting there and more time being there. Viking River Cruises, exploring the world in comfort.
Now, we've obviously long heard, we're going to put this to our panel, that George Zimmerman had a gun and he was up against an unarmed 17-year-old. The defense, very sensitive to this, trying to make the jury think about this in a different way. Listen to what Mark O'Mara said this morning during his closing argument.
Now, I'll be held in contempt if I drop this, so I'm not going to do some drama and drop it on the floor and watch it roll around. But that's cement. That is a sidewalk. And that is not an unarmed teenager with nothing but Skittles trying to get home. That was somebody who used the availability of dangerous items from his fist to the concrete to cause great bodily injury. Not that it's necessary for self-defense, but great bodily injury against George Zimmerman. And the suggestion by the state that that's not a weapon, that that can't hurt somebody, that that can't cause great bodily injury is disgusting.
The defense clearly sensitive here to what we have heard from the prosecution, that George Zimmerman was armed with a gun and Trayvon Martin was armed only with iced tea and Skittles. Tanya Miller, a former prosecutor, current defense attorney, do you think this was effective, or was this too much?
I
thought it actually fell a little flat. The problem with this demonstration was, one, the state never said that the cement couldn't hurt you. What they said is that George Zimmerman is exaggerating the extent of his injuries, and that Trayvon Martin didn't use the concrete and the cement in the way that George Zimmerman says he did. And I think the state effectively pointed out in the rebuttal all of these lies and inconsistencies in his statements, including the injuries, and the defense did not effectively deal with that in their closing argument. And I think this was a feeble attempt to do it. It just sort of fell flat. Of all the things you can show sort of righteous indignation about and be disgusted about, that just didn't seem to be one of them.
What do you think, Trent? Do you agree with that? I mean, you heard from the state. They pointed out Zimmerman said he was hit dozens of times, 25 times, but they say the injuries on the back of his head were not consistent with that.
Yeah. You know, look, I couldn't disagree more, frankly, and with regard to what Tanya said, you know, with regard to all these inconsistencies that we keep hearing people discuss, I'm not sure what they are. And to the extent they exist, they're really minor. In fact, even the chief lead detective in the case said that the inconsistencies from George Zimmerman's statements have all been minor. And when you talk about these injuries, look, let's call it what it is. I don't know that I'd want to have the kind of bruises on the back of my head and the gash that George Zimmerman had on the back of his head. I wouldn't want to have that and have someone call that insignificant. And remember this, look, if a woman, for example, walks into a police station and she presents with those injuries on the back of her head to a police officer, she will, by definition, that will be considered great bodily injury, and the police will go out, they'll arrest whoever did this. If it's her husband, it's domestic violence. That's the standard. So we can't take the standard in this case and look at it and say that George Zimmerman's injuries weren't severe, they weren't significant. And then in another kind of case, I do this every day, those kinds of injuries and less, and Sonny will attest to this, those kind of injuries and less will present in any court of law, in any police station in every county in this country as great bodily injury. So the reality is you may not consider those kinds of injuries to be enough for George Zimmerman to have reacted with a gun, to have shot Trayvon Martin, but strictly as a legal matter. He had the right to do that under Florida law because he presumed that he was going to face even greater injury, even more significant injury. And remember, the law doesn't require that there be any injury at all. So whether you like George Zimmerman or not, and I certainly understand folks who won't, the fact of the matter is that this is significant injury and it presents as such.
And as we heard, the jury will consider, did Zimmerman respond reasonably? That is very much at the heart of this. The jury continuing to deliberate in the George Zimmerman trial. We'll be right back in just a moment to answer the question of how long it might take them to come to a verdict.